Let's turn to the petition, which is the form that we have here, which should have been in the materials. I apologize for the fact that it's not.
When you put it in the software, you're gonna put the whole social security number. If you're doing a form like this, handwritten, you're gonna only put the last 4 digits. The software will actually hide the beginning digits when you file it, and it will make these X's for you. If you're doing this by paper, you just wanna make sure you put the last 4 only, because otherwise you're breaching confidentiality, and the court will kick it out. And then you put the address of where they reside. This person was on Moore Street. And then the county of residence. Obviously in DC, there is none, but if you're in Maryland, put Frederick, Prince George's County. The software will actually populate the county for you, and it populates the city if you just put in the zip code. It's great, because it will do so many different shortcuts for you that you have to do less work. And then if they have a mailing address, some clients of ours decide that they don't want the mail going to the residency. They may have a PO box they want it to go to. They may be in transition and have moved out of a property they're getting rid of, and they have a different address. Or it's a business and they don't want their bankruptcy paperwork going to their business. They rather have it go to the residency. That's an option too. Sometimes it's for private reasons. They don't want somebody in their family knowing they filed, so they want to send it somewhere else. And then the location of principal assets of business debtor, this doesn't apply here. Then we want to go down to the next box. This is where you list the type of debtor this is. For your cases, this will be an individual, but if it was a corporation or partnership, you would check those boxes. This isn't business, so there's nothing to check in the other box, but if it was, it'd be one of the natures of business if it applies to you. And then you pick what chapter you're filing, whether it's 7, 9, 11, 12, 13, 15, we don't do that. Tax exempt, you won't worry about that. And then the nature of the debts, if they're primarily consumer debts, which yours will be, or you could have a consumer debt who has a lot of rental properties or business transactions. So in that instance, it has to be more than what, 51% of their debt is business related. You can check that box and use that instead of consumer debts. The filing fee, I'm assuming the court went over the filing fee and how to waive it and all that paperwork. You would click the box there and the filing fee would be attached. If you do all this electronically, you don't even have to do all these boxes. You really only have to do a couple of them because they're automatically defaulted. Once you hit chapter 7 and you hit what kind of debt it is, it automatically populates everything else for you. Chapter 11 debtors, this would not apply. Then you get down to this is your statistical information. You just basically guess how many credits you have and how much assets you have and liabilities. You're not stuck with this. This is just your best guess. If you're using the software, it populates based on when you put in your creditors in Schedule F. It counts how many it is. It counts up the amount of debt owed. It counts up your amount of assets. So it would automatically populate this for you, and you don't have to do anything for it.
Let me just call your attention above the last 3 boxes, which are the statistical information. There is a box that has 2 choices: debtor estimates that funds will be, or debtor estimates that after any exemption is excluded, there will be no funds available. You remember we talked about whether or not a bar date for the filing of proofs of claim is set, and creditors are given notice of a deadline for the filing of proofs of claim. The way that the clerk's notice sets a bar date for the filing of proofs of claim or not is based on this box right here. The 4th box up from the bottom where it says statistical/administrative information. If the first box is checked, that means that the preliminary conclusion you have drawn, is that there will be money available to pay creditors. If that box is checked, the clerk will set a deadline for filing proofs of claim. The second box says that although there may be assets, after you take out all the exemptions, there won't be any assets remaining to pay creditors. If that second box is checked, the clerk will not set a bar date because there's no purpose to be served in filing claims where there's no money to be distributed. So that's a very important box, but it is not binding. This is your preliminary estimate as to whether there will or will not be assets. Once the petition is filed, a trustee gets appointed. The trustee conducts an investigation of the assets and liabilities of the debtor, and the trustee may conclude that this is a case where you may think there aren't assets. The trustee may think this is a case where there are assets. If that is the circumstance, then the trustee has the ability to notify the clerk and to ask the clerk to set a bar date and give notice to all the creditors of the bar date for filing claims. So if the bar date is not set based on this box being checked in the petition, that is not necessarily the end result. The trustee may still make a determination and make a request that a bar date be set. Okay? But your best guess based on the information you have when you're preparing the petition is what you put here. And in most cases, your conclusion is going to be that there aren't assets available for distribution to creditors.
And just so you know, if you ever do a Chapter 13 or 11, a bar date is automatically set upon the filing of the case. So it sets a bar date because in a 13 and 11, you're paying back some portion of your debt to the creditors. So that's where the instance where you would definitely check that box. Doesn't matter how much they're going to pay back, but you would check it for a 13 or 11 so that the court sends out the notice. Okay. Then the next page is where you list if there's any prior bankruptcies they filed within the last 8 years, or if there's any pending cases filed by their spouse, partners, or affiliates. In this case, there are none. And then you sign, your attorney signs under Exhibit B.
Exhibit B is your certification as debtor's counsel that you told your client about the existence and potential availability of other chapters of the bankruptcy code besides the chapter they're filing under.
Then Exhibit C, you check no, you don't pose a threat or harm to public safety. Exhibit D is the credit counseling course that they'll take that you'll attach as an exhibit to your petition saying that they took this course on such and such date, and you attach the certificate as proof of that course. And then the next one is information regarding the debtor, and this is where you check the venue. Has the debtor been domiciled or a residence, principal place of business in the district for 180 days preceding the date of the petition or for longer?
The last box on page 2 is what we were just talking about. This is the provision governing the extension of the automatic stay to stop a residential eviction. In order to get the stay to prevent a tenant from being evicted from residential real property, all 4 boxes must be checked. The Landlord-Tenant Division here in DC is going to look for a copy of the petition with all 4 boxes being checked before it will order an eviction of an individual tenant from residential real property to be stopped.
And then the last page is the signature page is for your client and for you as the attorney or corporation. So this is basically what you file to start and get your case number. All right?
Okay, so that's the petition, and we've been through the schedules. I'm not going to recite them again. Everybody's eyes roll back in their head when I start to do that by this time. So the petition and the schedules. In addition to the schedules, there is another document called the Statement of Financial Affairs, SOFA, sometimes referred to as the SOFA, or Form 7 for the form number geeks. But the Statement of Financial Affairs, unlike the schedules, involves answering questions in a somewhat more narrative form than just list all the contracts you're a party to. So the Statement of Financial Affairs is something which accompanies the schedules, but unless the debtor is engaged in business, the debtor does not have to answer questions 19 through 25. If the debtor is engaged in business of any kind, then questions 19 through 25 have to be answered. but all debtors have to answer questions 1 through 18.
And this is probably the hardest piece of information to get from the clients because it is, what is it, 9, 8 pages of it, paragraphs, extensive reading. They don't always understand what the questions are. So what I try to do is highlight in my email to them, definitely need to answer 1, 3, 4, 7, 8, because I know these apply to you, and kind of read through the other ones to see if they do. But this is the one where their eyes roll back and they gloss over in a haze because it is so much to look at and to read, to digest. And it has years and all that. So we start with the first one, which everybody most likely will have, is income from employment or business. And you want to list the amount of income they received year to date in the year that you're in, and then the prior 3 years. So for this guy, 2010, I'm pretty sure that's when he retired. He didn't make any money at the county center. So the time, I think I filed his case in January, maybe he just retired. He had no income, so I listed it. Then in 2009, he made $8,300, and in 2008, he made $7,500. So for instance, the schedules I would file today would be 2014 from January to June 12th, and then ask him for a year-to-date for everything for 2013, 12, and 11. And then for number 2, this is for people who have income from stuff other than employment or business. This is Social Security, annuities, unemployment, any kind of money they received from sources that are not their job or operation of a business. Same thing, year to date and in the last 3 years. If it's a husband and wife, you want to list them out, I do. Husband, 2014 amount, wife, 2014 amount. It's cleaner, it's neater, it looks better, it's easier to see. So for instance, if you look, he has pension, and he had Social Security, and he has annuity. And then number 3, this is where you list the payments you've made to your creditors. Not your everyday creditors such as your cable, or your phone, or your gas, unless you were behind on it and they are a creditor. But this is to your mortgage company, this is to your car lender, this is to Sally Mae, this is to a credit card. Maybe the last 5 months you were trying to pay American Express off. So you would list the amount that you paid in the last 90 days. So for him, he paid Fifth Third Bank, which was his car lender, I think, and he paid them on February, March, and April 10th, and the amount he paid. I usually don't worry about the amount still owing. If they provide it for you, great, but I don't make them have to go back unless it's handy and they can do it. But you want to make sure you include everybody, because a trustee is looking to see, did you pay one creditor off and not other creditors? So say you wanted to keep your Kohl's card because they have really good specials, and you wanted to pay it off in full, the $20,000 you owed. If you sent them a check for $20,000 in the last 90 days, the trustee's going to look at it and he's going to say, nope, I'm getting that money back because you didn't pay Target, you didn't pay Walmart, you didn't pay any of these other creditors. So it's important that they give you an accurate list of exactly how much, how often, and how many payments they made for that 90 days before.
All right, let me interject here that this is a big bankruptcy policy. Bankruptcy is designed to prevent creditors from rushing to the courthouse, rushing to get judgments, and rushing to basically dismember a debtor and to collect ahead of everybody else. The idea is we want all creditors who are similarly situated to be treated basically the same. So all unsecured creditors should basically be treated the same. We don't want to reward somebody who makes too much of an effort to get paid to the exclusion of other creditors who have equal standing but simply aren't as aggressive in collecting or for another reason get paid. For example, one is you want to keep a particular card, although that tends not to work. But a debtor may decide, look, my sister co-signed this personal loan for me. I'm going to take all of my money. And instead of paying everybody, I'm just going to pay this one creditor where my sister co-signed to make sure they are paid off before I file bankruptcy. Picking and choosing what creditors to pay during the slide into bankruptcy, and that 90-day window is regarded as the slide into bankruptcy, like it's an amusement park. That's called a preference. And preferences are defined and described in Section 547 of the Bankruptcy Code. And a preference is any payment to a creditor on account of an existing debt made within 90 days prior to the bankruptcy. And this is in 547. You can review that for the technical definition. And what a preference does is it allows certain creditors to get paid where other creditors similarly situated aren't getting paid. And because the bankruptcy policy is to result in equal payment to creditors or equalizing payment among creditors, under Section 547, the Chapter 7 trustee is empowered to go and sue the creditor you preferred, to sue the recipient of the preferential transfer, to recover the preference and bring that money back that was used to pay one creditor and pay instead equally amongst all creditors who are similarly situated. Preference actions are one of the largest resources for Chapter 7 trustees to create bankruptcy estates. The litigation is fairly straightforward. There is a technical definition. It's not like you have to prove intent. You simply get 90 days worth of checks from the debtor, go through them, find out what they paid, and sue anybody who got paid where other people were left unpaid during that same period of time. Section 547C was changed many, many times, and it provides a list of defenses. And those defenses that are available to the creditors who received preferences and preferential transfers have grown and become simpler and easier and much broader. And it includes things like an ordinary course payment. If the payment was made in the ordinary course of business, it can't be recovered as a preference. So what's ordinary course? Well, it used to be that it had to be ordinary course for the debtor, ordinary course for the creditor, and according to ordinary business terms. But they changed that, so it could be any of those three things instead of all three of those things. And the idea was that while everybody was getting sued for the first 20 years of the Bankruptcy Code to have their preferential transfers recovered by the trustee, in the last 10 years that's been flipped on its head, and the availability of the defenses have cut down on the ability of the debtors, the ability of the trustees to recover preferences. But question 3 is what alerts the trustee to the existence of potentially recoverable preferences. What payments have been made to what creditors during that 90-day window prior to bankruptcy? And then if you take a look, that's 3A. 3C talks about a 1-year reach back for preferences. If the creditor who was getting paid is a relative, then that 90-day period stretches back to 1 year. That's only if they are a related party to the debtor. If it's a truly third-party creditor, like a credit card company or a doctor bill, it's 90 days. But if it's your Aunt Tilly in San Francisco, then Aunt Tilly is subject to a 1-year reach back for preferences. The trustee files an adversary proceeding in the bankruptcy court to recover the preferential transfer. The recipient of the transfer, the transferee, gets to defend. At some point, if it's not settled, and most of them are settled, there'll be a trial and the court will decide whether or not the preference has to be returned or disgorged by the recipient. If it is, then the trustee gets the money back. The trustee is not entitled to recover his attorney's fees. So there's a real economic analysis the trustee has to do about whether it's worth suing to recover a preference. And in fact, one of the defenses to a preference is that it's for less than $600. You can't recover a preference for less than $600. It's just not worth it, so it's been established as a statutory predicate. But a trustee may say, look, the preference recipient is Aunt Tilly in San Francisco, and here I am in DC. I really don't want to sue Aunt Tilly and then try and have to collect from her in San Francisco. I'm just not going to bother. That is subject to the trustee's discretion. The trustee is not required to bring actions to recover preferences. This is a matter of the trustee's sound business judgment. But question 3 in the Statement of Financial Affairs is where the 90 and 1 year preferences are disclosed by the debtor. Okay.
And a lot of people leave this blank, and you'll know for a fact that they paid their mortgage because they're current on the mortgage. And you know the last 3 months they paid it, but they left this blank. I saw one last week. I was like, you didn't pay your mortgage or your car? Oh, yeah, I did. Why didn't you list it? I didn't understand. I'm like, okay. So you wanna make sure that if you know they have secured debts and you know that they're current and they're making those payments, list it. You may not know the exact date they made those payments. I usually just put it for the first and the last, but I know they made it because I know they're current. Then the next one is suits. These are all lawsuits, civil cases, anything in the state or federal courts. This is where you list if a bank account is frozen or a garnishment is issued, a wage garnishment, or something's been seized. You want to list it because you want to try to exempt it and get it back. Or the trustee can go after these assets as well. A lot of these, I just look on the case search. If it's Maryland, I go on and I look for our client's name to see if there's any lawsuits pending on them, and then I just list them, bang, 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 down in order. Then number 5 is that they've had any repossessions or foreclosures or returns. Maybe their house has been foreclosed and they didn't know, or you can find that online too, on the case search, but you want to list any of a car, voluntary or not, repossessions or returns of any property. I don't deal with assignments and receiverships, actually never. And then gifts. This is if you are giving gifts to charity, Goodwill, Purple Heart, things of that nature, or charitable deductions. Within the last year, you want to list all those out as well. And then this is where we talked about earlier, losses from fire, theft, or other means. Gambling is a big one. I've had quite a few clients who have had large gambling debts and losses that I had to account for. So you want to make sure you list that. You want to get on it before the trustee finds out about it, so you have it disclosed. And then number 9 is the payments that they make either to you as the attorney or to the credit counseling courses or a debt consolidation. Years and years ago, we had clients that were coming in who had tried these debt consolidation programs without any luck. And they were paying thousands and thousands, this guy had one, $1,780. I don't really see those anymore, but you want to make sure if they had any kind of relationship with that, you want to list as well. And then 10 is any other transfers of property in the ordinary, other than property transferred in the ordinary course. So if you sell something to somebody or you transfer that ownership from yourself to another person, you want to list what property was transferred, what was the value you sold it for, and the date that it was transferred. The trustee's looking to see if you're disposing of assets or have been, and it's with a 2-year look back for this one. Just want to make sure when you look at the questions, you make sure that you have, whether it's 90-day, a year, 2 years, 3 years, that you have all that information. And then 11, many clients will have closed an account because somebody's going to attach a garnishment to their account or freeze their account. So they'll go in and close it and open up an account that they don't owe any funds to, or they have no debt that they owe that bank. So this is where you would list any closed financial accounts. Safe deposit boxes, I think I've seen just a handful over, yes.
Does 11 include accounts that were closed by the bank against your clients?
Yes. Anything that was closed within the last year, whether you did it or they did it, just make sure you list it. Safe deposit boxes, I've only seen a few of those over the years. You just want to list where it's located, what's in the safe, and the value of what's in there. And then 13 is set-offs. I don't feel much of that. 14, I actually did this last week. This couple had a bunch of tools and lawnmowers and such owned by somebody else, but it was in their backyard. So they listed it because technically it's on their property, but it's not theirs. They're holding it. Or some people will hold a vehicle. Maybe a child is away at college. It's the child's vehicle, but it's in your driveway. You'd want to list it so that the trustee's aware that you have this piece of property on your property, but it's not yours. It's registered to somebody else, and you're just holding it. Prior address, if they've moved in the last 3 years, you want to provide any of the addresses they've lived in. And if they're married or had any former spouses, you want to list that as well. And then usually, if it's not a business or a corporation, I don't answer any of the other questions unless they are engaging in some sort of self-employment or business venture.
Okay, the statement of financial affairs. You can see that with the exception of the first couple of questions, typically most of the answers here are none. especially for consumer individual debtors in Chapter 7, it's pretty rare that you see more than the first few questions get answered. And that the answers tend to be relatively short, with the exception sometimes you may see a lengthy list of creditors who got paid during the 90 days or 1 year prior to the filing of the bankruptcy. Or like that particular debtor, there was several different components of their income over the 3 years preceding the filing. So now we've gone through the petition, we've gone through the schedules, and we've gone through the statement of financial affairs. These make up the bulk of the documents that are due, not the petition, but the scheduled statement of financial affairs that are due within 14 days of the filing of the petition. There are other documents as well, and if you continue forward.
I just closed another example. The next page is another example of a Form 7 where there is a lawsuit and there are other options that he had so that you can see different types of answers you would have to the same questions. And the one we just looked at, he actually had a photography business, so I showed what you would do if they actually had a business. Maybe they make cakes or they do parties or something like that. You would list that as their business. So I just showed you a couple examples of things you could come across.
Okay, the next document we want to look at is the means test. And this is the one which is either very easy to file or requires more math than I've done since 7th grade. The Chapter 7 means test is the threshold by which it's determined whether or not your debtor, your client, is eligible to file Chapter 7. And you remember that the chart that we showed you on Tuesday and the chart that we handed out today shows that the median income for DC for a household of one is $46,464. For 2, 3, and 4, it's shown what the numbers are on the chart. And these are the cutoff figures for eligibility. The means test form, Form 22A, is the form which you fill out in order to demonstrate and calculate exactly how much the debtor's income is for means test purposes to determine if they're eligible to file Chapter 7 or not. The first thing on the first page is whether or not these people, your debtor, is involved in, is in the military or is a business debtor. If they're in the military on active duty or if they are a business debtor, they do not have to do the means test. So you can stop immediately if the majority of their debts are non-consumer, or business debts, or they're active duty. Assuming that they're not active duty and that the majority of their debts are consumer debts, then on the next page in Part 2, we start the calculation process. And Part 2 carries over to the very top of the third page, and it's simply items that are taken directly from your client's paycheck. Now keep in mind that some paychecks are biweekly, some paychecks are semi-monthly. Whatever the pay period is, you have to calculate what it turns out to be on a monthly basis. And make sure you do that, because I've had the unfortunate situation where I spent an incredible amount of time doing the math for someone only to realize that I had been using their bi-weekly paycheck instead of doing the math to figure out what the monthly gross and net were going to be. So doing it on a monthly basis is fairly easy. If somebody gets paid twice a month regularly, a bi-monthly paycheck, semi-monthly paycheck, then you simply double each paycheck's figures to determine the gross and net on a monthly basis. If someone gets paid every 2 weeks, I think we went over this on Tuesday, you have to multiply the numbers in the paycheck by 2.33 to get the monthly amount from a bi-weekly paycheck. So, question 2 is an identification of the debtor. What kind of debtor do we have? Is the debtor married or unmarried? Question 3 is, what is the gross income on a monthly basis that is shown in these paychecks? Question 4, question 5, question 6, question 7, question 8, question 9, and question 10 are all questions designed to elicit answers showing what income the debtor receives on average on a monthly basis from all sources.
Except for Social Security.
Right.
Social Security is not factored at all in the means test whatsoever. So for the guy that we showed in the income, he only gets Social Security. Everything here is zero, it's filed as zero, because you don't consider Social Security income when you do the means test. But unemployment, workers' comp, annuities, everything else is included in here. Rent, pensions, everything else, but Social Security.
Child support?
Yes. Alimony, everything.
Okay, boxes 11 and 12 both require that you put down the total of the debtor's monthly income from all sources. So turn to the third page, you'll see at the top it says total monthly income. And in this case, it's $1,578.17. Now, part 3 is where you do the comparison of the debtor's income to the median income for their household size in that state. So this person had a household of 1 in DC. So in part 3, the first thing we do is we take the monthly income and multiply it by 12. And that takes us to $18,938.04, which is the annualized monthly income of this debtor from all sources. Then, from that chart, we find what the median income is for that household size in that state. This is a household of 1 in DC, and at the time, now it's $46,464. At the time, it was $42,340. If their annualized gross income is less than the median income for their household size in DC, stop right there, because that means they are eligible to file. End of analysis. If for some reason the gross annualized income is more than the median income for a household of their size in DC, then you have to compute all of the rest of the deductions in the balance of the means test in order to determine whether or not the deductions bring it back down as net income below the median income for their household size in the District of Columbia. And you can see that there are subparts for the standard household expenses for food and clothing and health care, child care, education. There are additional living expenses that, like insurance, that you're allowed to deduct from your gross. There are payments on mortgages or car notes that you are allowed to deduct from your gross to determine the means test net income. And finally, you see subpart D on the 6th page. It says total of all of the deductions. And when you total up all of the deductions, then you get to part 6, which is whether or not you have succeeded in reducing the gross to a net that is below the median. So in this case, you take the annualized monthly income and you take the deductions and show what is the monthly disposable income to determine whether or not they qualify based on the amount of excess income that's available to them.
And the software does all this for you. So you just put in the amounts. It gives you all the IRS tax deductions and automatically puts it in there for you and spits out the number of the smiley face or the sad face at the end of the paper. Another thing you want to think about when you're doing these cases, you're not going to have a run-in with the means test because these people are already going to be below or at poverty level. So them meeting the means test or making more than $46,000 in DC is going to be very, very unlikely. But if you decide to do this on your own, you will have a client that will come in, say they make $70,000, $80,000, but they have 2 houses and they have 5 cars and they have all these things and all these deductions, all these children. You can take all of that and lower it down. I was just thinking the one we had, the couple made, it was a close one, the one you just went to in Maryland. They made $140,000 in a household of 4 in Maryland, and they had a house and a car and daycare, which when I got down to the bottom, $5 was the difference between them making it, and, because I had a sad face at first. And then I was like, I gotta call them and find out if their daycare really is $800 a month, or maybe it's $1,000. So I called them back and I got it down to where they were positive for $5. So he went to the trustees, so you were at the credit meeting. I was waiting for the court to pull up the no asset and not flag it because we're so close that it could have gone either way with the numbers because they made so much money. And when the trustee finally filed his no asset report and I got the email, I was like, oh my God, thank you. Because that means I passed the means test, there's no abuse, and they can stay in a 7 and walk away and get their discharge. But it was close. I mean, I was crunching numbers. I would leave the night and come back the next morning and try to crunch different numbers, try to move, like she got sometimes overtime, so I had to go back and figure out over the course of how many months, how much overtime was she getting. He travels for work all the time, so sometimes he makes more money on the road. I was so thankful, this was like 2 weeks ago that when that came out because I passed the means test. Because the trustee could come in and say, well, that taxes look really, really high, and then pull the pay stubs and find out that maybe you put the wrong number in, or maybe you put too much in for one thing. And he could say it's an abuse and tell you you need to file Chapter 13 and convert you. So it's really going to make sure that you have as much as you can get into this table if it's close. Yes?
For the pro bono participant or the attorneys, is the software that you're referring available on the laptop that they provide us?
Yes,
Okay.
it's already in here.
All right, one thing I want to call your attention to, and this is some of the strategic planning that you may have to do for not necessarily your pro bono debtors, but again, if you continue on doing bankruptcy cases for consumer debtors. If you take a look at page 8 of the means test, it's an attachment called Current Monthly Income Details for the Debtor. This is a debtor who was unemployed for 3 of the 6 months preceding the filing of the bankruptcy petition. When you are asked for the average monthly income of the debtor, it is an average of the 6 full calendar months preceding the month that you're in. So we're in June, so the means test income is an average of the 6 months ending with May. So it'd be December, January, February, March, April, and May, based on the income, gross income that the debtor received during each of those 6 calendar months. Now in this case, for the first 3 calendar months, the debtor was unemployed and received nothing. Then they got a job with Metro and received $2,500, $3,400, and $3,400 in the last 3 months, the most recent 3 months. Now, the means test average income is an average of these preceding 6 months, which means that if the debtor you are talking to has variable income, it may be that any particular 6 months may produce a higher or a lower average for the preceding 6 months. And since the amount of the income on a gross basis may determine by itself eligibility for Chapter 7, and the gross income also affects what may be the net income if you don't meet the means test in the first step, then the question is, can you time the filing of a bankruptcy petition so that you capture the best possible 6 preceding calendar months? And the answer is absolutely.
Assuming you don't have a emergency like a
Right.
foreclosure. I mean, we've had cases where our one guy, he gets commission. So 1 month he'd get $15,000, and then he'd get the next 3 months, you know, his regular salary, and then he'd get a bonus at the end of the year, and it'd be $30,000. So I'm sitting here, we're trying to figure out when's the best time. He didn't have any foreclosures or anything like that. So I was waiting for the 1 month to fall off, the 10,000, so that I'd have the regular months and then maybe a little bit one. But I've waited, you know, sometimes 3, 4, 5, 6 months for these people. Or the one lady, she retired, she got a lump sum payment. I had to wait for 6 months because she got like $30,000 or $40,000 paid out from teaching.
And she was making so much when she was employed that her average income would disqualify her. But we waited until she retired when her income dropped from her original working compensation to her retirement level, and then we waited a couple of more months so that the average of the 6 months included more months at the lower income, so that the average would go down based on more months at lower income being included in the 6 months. And here, we did the math. And you see in the manual on page 8, we did the math to figure out when was the latest we could possibly file and still keep the average income low enough that for sure we would pass the means test. And it just so happens that we could wait until this particular debtor had been employed for several months out of the preceding 6 and still keep his average well below the means test eligibility cutoff. So if you don't have a debtor who's got to file for some reason sooner rather than later, and you've got someone who, for example, is intending to retire or received a very large bonus, and you can afford to wait so that, for example, that bonus is now in the 7th or 8th month ago, so it doesn't have to be included in the 6-month average, that's something that you should look at doing if the math justifies it. For a lot of people who don't have bonuses, who don't have retirement, who don't have changes anticipated in their compensation, it may not be possible, but I'll give you a good example. School teachers. Some school teachers work on a 12-month compensation basis, but some of them work on 10, which means that for 2 months they have 0 income. Well, those 2 months factored into the preceding 6-month window may dramatically affect the average income for those 6 months. If you do it during the school year, their 6 months may all be paid months. If you do it so that the 6 months includes the summer, then you're potentially dropping their average income by 1/3 because they will have 0 income for 2 of those months. So anyway, this is an example of the detail of that kind of analysis.
I was thinking, or somebody who had a job who made a lot of money but then got laid off and is going back to
Yeah.
work. And so you may wait for 4 or 5 months till his income is gone 0, 0, 0. So you only have 2 months of a really high salary and then 0, 0, 0, 0 to do it. It's a numbers game, and if you have time to wait.
Is
Right.
there any, does the trustee look and say, okay, you were unemployed for the last 6 months, so your average income is 0, but, now you're making $10,000 a month, you calculate or something?
The short answer is that they can do that, but it is exceedingly rare. If somebody's new income is still not excessive relative to the means test median applicable to them, the trustee's not going to bother. So if somebody is going from unemployed to making $50,000 in a household of 1, they're not going to bother.
But
Yes.
you still look at the filing date though, right? So
Yes.
that's really the cutoff.
Right, so,
Okay.
but you pick the filing date.
Okay.
So you just pick the filing date that has the best possible average for the 6 months, the best possible 6 months to give you the average, if there is any possibility of a means test fight. Okay, so we've been through the petition, the schedules, the statement of financial affairs, and the means test. Next, we're going to turn to a document called the statement of intention.
Statement of intention is only filed in Chapter 7 cases. And basically, you're stating your intention with your secured property. So for instance, this guy, he had a Harley-Davidson motorcycle, and that he wanted to keep that motorcycle and continue to make the payments. So on his statement of intention, I filed it saying he's retaining it, he's gonna continue to make his payment. This would also be for mortgage companies. Wells Fargo, maybe they decide they don't want to keep this property, so you would put surrendered and you'd file it. You have to file it with all the other paperwork. One of the things I've seen it's happened is that at one time the client decides they don't want to keep it, and then 2 weeks later decide they do want to keep it, and then the next week they decide they don't want to keep it. So basically, I've had to file like 4 or 5 amended statements of financial affairs, or statements of intention based on whatever decision they've decided to make that week. That's not a problem, but just need to make sure that you file this and file it with whatever they want to do with it, whether it's keep it, or surrender it, or redeem it, or reaffirm it.
Okay, let's talk for a second about reaffirmation. As I said, the discharge wipes out the in personam liability of the debtor for their debts. A reaffirmation agreement is what it sounds like. It's an agreement for the debtor to resume in personam liability for a particular debt. Now, why would someone do that? The answer is typically a debtor will never want to do that. However, certain creditors may insist upon it, and the court typically has to approve a debtor's decision to reaffirm a debt because it undoes what a bankruptcy normally does, which is wipe out that liability. So if a debtor is going to reaffirm, is going to resume personal liability for any debt, the court wants to make sure that either the lawyer has determined that it's an appropriate reaffirmation or the court has determined that it's an appropriate reaffirmation. And what would be an appropriate reaffirmation? Typically, reaffirmation agreements are limited to secured debts. And even in the universe of secured debts, reaffirmation agreements are most commonly used with respect to vehicles.
And furniture and jewelry.
And furniture and jewelry, but not mortgages. It is typically not necessary to reaffirm, to affirmatively reaffirm a home mortgage. It is typically necessary to reaffirm a vehicle. The purpose of reaffirmation is essentially so that the lender knows that the borrower continues to have some skin in the game. That the lender knows that the borrower has some personal risk in the event that the collateral is lost or damaged, so that the value of the collateral winds up diminished. The individual is still personally liable. So the borrower, the individual borrower, has a reason to protect and insure and preserve the collateral. And that is that they are once again liable if that collateral doesn't fully pay off the debt. Because remember, if the debt isn't reaffirmed, they have no personal liability. They could allow the collateral to be burned to the ground. They could allow the collateral to be driven by miners. They could allow the collateral to be driven into a brick wall, and they have no personal liability if that collateral is destroyed or reduced to $1 in value because their in personam liability has been discharged. So the secured creditor says, if you're going to retain the collateral, I need to know that you've got some personal stake in maintaining and protecting my collateral while you continue to retain it and use it. And the way I put you at risk so that you will take care of my collateral is for you to agree that in the event my collateral for some reason doesn't pay me off, you're going to pay me off from some other resource. And that is the premise behind a reaffirmation agreement. If you want to keep my collateral, I have to know you're putting yourself at risk that I don't get paid from my collateral. So you will work to protect my collateral and to get me paid. Typically, debtor's counsel considers whether or not the reaffirmation is appropriate in the context of whether or not the payment of the obligation reflected in the reaffirmed debt is a hardship or not. And the court will do the same analysis with the debtor. Is it a hardship for the debtor to have to reaffirm this debt? So what would be a hardship? Well, the bankruptcy courts hate permitting reaffirmations on cars that are grossly upside down. Why should somebody agree to pay $12,000 and potentially be personally liable for $12,000, notwithstanding their bankruptcy, for a car that's only worth $4,000? The bankruptcy judge will typically ask the debtor, can't you find another car for less than $12,000? Because you're paying $12,000 to buy a car worth $4,000. If you take $8,000 instead, you can go get a car worth $8,000. Why should you reaffirm this debt? And you'll hear the debtors standing up there going, well, I really need this car for transportation. And the judges say, then go and get a car for less than the $12,000 you're going to pay for this $4,000 or $2,000 car. But I'm not going to let you reaffirm. And if the debt is not reaffirmed, the car company has the right to repossess the car because the filing of bankruptcy is a default. It is an uncured default under every car loan document. An event of default includes the filing of bankruptcy. If you don't cure it, you're in default. The debtor is liable to have the property repossessed unless they reaffirm the debt. If the court says no, then the lender can repossess even if the payments are current. Even if the payments are current. The filing of the bankruptcy is still an uncured default, and the car lender can go and pop the car, and does. Routinely, Ford and Toyota are notorious for popping cars of people. They may be current in their payments, but because the bankruptcy has not resulted in a reaffirmation, they go and they pop the car. Yes.
So if a person reaffirms, say a car debt, and they hadn't been paying during the course of the bankruptcy, would that reaffirmation could it include back payments?
Yes.
Okay.
Yes. Typically what happens is, as part of the reaffirmation agreement, the debt itself is restated. You know, the original promissory note may be $16,500, but at the time of the reaffirmation, the principal's been paid to $9,000. So the reaffirmation agreement says you're reaffirming $9,000 of the debt on the following payment terms. So the lenders do that.
It's usually the same interest rate and the same monthly payment you were paying, assuming that you weren't behind. So if everything was the same way it was when you went in, it's usually the same way you're gonna come out. But I have seen a couple where they've lowered the interest or knocked some money off
Yeah.
of it.
But if you were behind, do they just stick the payments on the end?
Typically, yes, the debt you reaffirm is restated and the arrearages are rolled into a new repayment structure.
Does
Yes.
this have to be filed when you originally filed the petition?
No, it has to be filed before the discharge is entered.
What,
Before the
reaffirmation
discharge? So
agreement?
if
Yeah,
you
no.
filed a petition and, so the car could be repossessed before you file this?
Before you file bankruptcy, because remember, the automatic stay stops repossessions during the case. During the case, during this breathing spell of the automatic stay, this is when the car lender gets notice of the bankruptcy and says to the debtor through debtor's counsel, if you're going to keep the car, you have to maintain the payments and reaffirm the debt. And here's our copy or our version of a reaffirmation agreement. So dear lawyer, read this over, certify that it's not a hardship, and get your client to sign it. And at that point, they have the debt restated, and the lawyer's signature is a certification that it's not a hardship. Typically, the court will accept the debtor's counsel's signature. But if there's no debtor's counsel, then typically the court will have the debtor come in so that the court can explain and ask whether or not it's a hardship. Yes.
I was a little confused by what you said previously based on what you just said now, because you mentioned that the filing of a bankruptcy is considered a default
Yes.
on its face for a car.
Yep.
So you were saying that they can still repossess it, or does the automatic stay prevent
The
it?
automatic stay prevents it when the case is over
Okay.
and the automatic stay is no longer there. Remember, the in rem right is never discharged.
Okay.
So the car lender reserves and preserves its right to go and pop the car. Even if the payments are current, because there was a bankruptcy and the debt was not reaffirmed, that bankruptcy default provides the predicate for the car lender after the automatic stay has terminated to go and exercise its in rem rights with respect to its collateral, which is pop the car. Yes?
Do you know why a company would do that? I mean, if the debtor wants to pay, is willing to reaffirm, if you said like Toyota.
Yeah, the reason is that the car lenders especially are concerned that if there is no personal risk on the part of the debtor, even if they're making payments, if the debt is not reaffirmed, the debtor always knows they can simply stop paying and they have no personal liability, even if they had allowed the car to just go completely to seed, haven't maintained it, haven't changed the oil in 70,000 miles, are driving on the rims. It doesn't matter to the car owner because they're not personally liable because they've received a discharge. The lender's only right is to get the car. And the lender says, I'm not going to run the risk that somebody who has no personal risk is going to retain my collateral, especially something as valuable as a car. So if they're going to retain my collateral, regardless of the fact that they're paying for it, if they're going to retain my collateral, I need to know that they are motivated to protect and maintain my collateral while they're retaining it and using it. So that's why they make that demand that it be reaffirmed.
Because you'll see, and I had clients a year after their discharge call me up and be like, I can't afford this car payment anymore, I'm just going to give it back to the lender. And they will. It's been a year since the discharge, they'll take it back in and surrender it because they haven't signed a reaffirmation agreement. And when we sit down with these clients and I explain to them, if you're even thinking that you may not make this payment down the road, or even thinking that you don't want this car, do not do this reaffirmation because you're on the hook for that debt. Otherwise, you can walk away from it. Just like I've had clients 3 or 4 years after their discharge say, I don't want my house anymore, I can't afford to buy, and walks away from it. So you have to make sure that they understand that they have no, in this small amount of time, they don't foresee that they're going to get rid of their vehicle. Some know from the start, they're like, I don't want it, and then they'll change their mind, yes, I do. I don't want it, yes, I do. You don't want them having anything to do with a reaffirmation agreement if they're on the fence.
All right, one last thing about reaffirmation agreements when it comes to cars. Here in DC, Judge Teal has basically said, if the debtor is current on its car payments, then really there is no need to reaffirm the debt because without a payment default, no car lender is going to be motivated to pop a car and run the risk of selling that car at auction and suffering a big loss. They're much better off continuing to receive the payments until their debt is fully paid. And so Judge Teal has decided, basically as a matter of policy, that when it comes to reaffirmation agreements on cars, he's not going to approve them if the debtor is current in its car payments. However, the bar has impressed upon Judge Teal the fact that these car companies, especially Ford and Toyota, have said, payments notwithstanding, the bankruptcy is a default, and if you don't reaffirm, we're going to pop the car. So Judge Teal has created a sort of comfort order that says, since the debtor is current in payments, I'm not going to approve a reaffirmation. However, I, the bankruptcy judge, can't believe that any car lender would be so stupid as to go and repossess a car for which it is receiving timely, full payments. So therefore, I am sort of expressing my outrage that a car lender would dare do such a thing, even though I'm disapproving the reaffirmation agreement. And on the, okay, well, it works in the other room. When we looked at the website with the clerk, one of the things that was available were links to the court's various opinions on these comfort orders, expressing the court's view of what the appropriate disposition of a secured claim, a claim secured by a vehicle, should be when there's a request for a reaffirmation but the payments are current. And it's sort of entertaining because it's kind of like the judge tempting fate with the debtor's cars. So it makes for interesting reading because it's an unusual thing that the judge has done here in DC. Did I see a question?
How often do you sign these, do you as an attorney agree to these reaffirmations?
When it comes to a car, if there's equity in the car, in virtually every case. If there's no equity in the car, then I need to really understand exactly what the judges ask, which is, why do you want to reaffirm a car where there's no equity? Why can't you use the same $400 or $200 a month to go and lease another vehicle or buy another vehicle? You know, I guarantee you that Easterns is going to sell you a car if you can afford $200 a month. Why are you paying, you know, $12,000 for this $4,000 car? If they can convince me that it's not a hardship and that they need this car specifically, then ultimately I'll sign off. If there's equity, I'll sign off automatically.
Yes.
What is redeem the property?
Okay. The alternative to reaffirmation is what's known as redemption. Redemption is a process available under Section 722 of the Bankruptcy Code. And what redemption is, you remember how we talked about how collateral may not be worth as much as the debt, and that there would technically be an unsecured portion. Well, other than real estate, the bankruptcy law says, instead of reaffirming a debt, you can simply buy the collateral from the secured creditor for the fair market value of the collateral. So if you have a car that's worth $2,000 and there's $12,000 of debt, you could reaffirm a $12,000 debt in order to continue buying a $2,000 car. That would be the reaffirmation route. Or you might not reaffirm and just hope they don't repossess it. Or you can redeem the car under 722. And since the car is worth $2,000, all the debtor has to do is pay the lender $2,000 and they get the car free and clear. That's redemption. Same thing with furniture, same thing with jewelry, anything that is subject to a lien other than real estate. The debtor has the right to redeem. But redemption has to be done in one lump sum payment. For some people, the amount of the value of their car is way too much for them to accumulate a lump sum payment. So guess what? Somebody created a finance company which is literally called 722 Redemption. That's the name of the company. And they will finance the redemption of a vehicle from another lender. So in our case, my debtor could go to 722 Redemption, I think it's 722redemption.com, and borrow the $2,000 against the car to redeem it from the original lender. So instead of having a $12,000 debt for the $2,000 car, they've now borrowed the $2,000 necessary to redeem it. And they only owe $2,000 for the $2,000 car. And it's a great thing. I mean, the interest rate, of course, is outrageous and you pay ridiculous fees for it. But it's still a lot less than $12,000 if you have to borrow $3,000 to pay all the interest and fees to get your $2,000 car. Did I say a question?
Does the creditor have to agree to that?
No. But the creditor can fight tooth and nail to say, that car's not worth $2,000, that car's worth $6,000. So you can't redeem unless you pay me $6,000. And if you can't resolve it, then the court has to determine what's the value of the collateral that you're seeking to redeem. I don't know if 722 Redemption will work for anything other than vehicles. Because with vehicles, they get a great lien by being able to put a lien on the car title. You don't have that same thing with household goods or jewelry. So I know it works for cars. So it's a very clever niche market that this particular lender has found to finance redemption. Yeah.
You mentioned that, I think you mentioned that sometimes people do this with furniture or other household goods. So if you say you're going to surrender it, do you personally have to return it to the creditor?
Yeah, he's got jewelry at his house, in his office, for a creditor to return. Hand it over to them and get that claim taken care
So
of.
you can't call the creditor's bluff and say, fine, pick it up.
You know, it's the rule governing the statement of intention is that it has to be filed and you have 45 days to perform it. So I'm not sure when you say you're going to surrender it, if that means you have to get a moving van and take it back. I was going to say Hecht, but it's not Hecht. And take it back to Ethan Allen Galleries or wherever it is and sort of leave it in their parking lot or something. Typically, if you're going to surrender the collateral, in good conscience, you should ask the creditor, where do you want to pick it up? Do you want us to deliver it? If so, where do you want it? If you have, for example, a leased vehicle and you want to give it up, you can do that in the context of the bankruptcy, and you take it back to the dealer and give them the
Cars
keys, and
are
that's good
easy
enough.
because they're portable.
Yeah, that's
And they're
where-
mobile, yeah, they have wheels on
I
them.
mean, but I've seen pool equipment, pool supplies, furniture, I just did a jewelry redemption. I think they owed like $1,500 and the creditor wanted $100 lump sum. Absolutely. I mean, that's a
Done.
big deal. They just sent me a letter saying, give me $100. I'm like, I told the clients, I'm like, done. So, I mean, the pool supply one, that was a weird one, because I didn't even know you could do that. But they didn't have the pool anymore, and the creditor couldn't produce the invoice to show what they had actually purchased, so we never did anything with it. That's the thing, if they can't produce copies of the receipts or the invoices to tell you what you're redeeming or reaffirming, don't do it. I've wrote letters saying, show me proof that my client has it, and they never respond. Never hear from them again, because they can't.
Okay, the next form I want to talk about is not an official form, it's a local form that we use just here in DC. If you turn the page from the statement of intention, you'll see a form called Statement of Record of the Debtor's Interest in a 529 account. Although it's under 521C of the Bankruptcy Code, it actually is the 529 accounts that we've discussed several times. And this is simply a statement that the debtor must sign and file indicating whether they do or do not have a 529 account.
And this is a form on the court's website that you go into under local court forms, and it's a PDF local form that you PDF and file. But only in DC, Maryland and Virginia do not have this form. Same thing with the next one, declaration of debtors regarding their pay stubs,
By the
only
way,
in DC.
The software has the local forms baked into it. So if you're using Best Case, there will be a pull-down menu or an expandable menu
Folder.
that has the local forms.
But I just go to the court's website. I've been doing it for so long that way that I forgot that you can, these are, Best Case updates their forms and adds new things all the time, so sometimes I don't even know what's on there. So for me, I still go there, but there's a folder for every little thing. And then the next form is where you say whether the client has pay stubs, maybe they're self-employed, they don't. If they do have pay stubs, then you check the box and then you attach the pay stubs to the form as an exhibit. Same thing, you can get off the court's website or you can get it off Best Case, but it's also one of the required DC forms that you have to file.
Okay, the next form is Local Official Form 12, which is a statement of no alteration. We've talked several times about the bare bones filing. Sometimes an emergency filing has to be made before the debtor can even compile a complete list of their creditors. So what they do is, let's say they're facing a foreclosure, you get them to get the certificate of credit counseling and you prepare the other documents necessary to commence the case. But everybody knows that they haven't had time to compile a complete list of their creditors, so you file what you've got in order to get the filing done to stop the foreclosure. Later, you have to file your schedules of assets and liabilities, and the schedules do have a complete list of all of the creditors, and effectively what you've done is you've now added creditors above and beyond the ones that were present when you filed the case initially. When you do that, that means that the mailing list the court maintains has to be changed. Additional notices have to go out. So if you make an amendment to add creditors, you have to pay a fee. To avoid that, if you are not adding creditors, you must fill out this local official form which says, I am not adding creditors between the filing of the petition and the filing of the schedules of assets and liabilities.
And if you forget to file this, the court sends you a notice saying, hey, you
In
have,
like every case.
yeah, unfortunately.
Because someone just forgets to do it in every case.
It's literally after you file the schedules and you're done, you're supposed to technically file this, but I always forget, so I always get my little friendly deficiency notice I'm sure Michael talked about, and it's my love note from the court saying, hi, you have 10 days to file this, or else I'm going to issue a show cause order as to why this should not be held and blah, 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 blah. So yes, File this as soon as you file the schedules, assuming you didn't add anybody else.
If you did add anybody, obviously you don't file this form and you pay the $30 fee.
And you file an amended matrix, which is on the court's website.
Okay, another form that I want to talk about is what's known as a 2016B statement. I'm not sure if there's even one in
No,
here.
it's not in here. I'm gonna make notes.
Okay. A 2016B statement is an official form, and what it is, it's the form that you file to disclose the fees that you've been paid. As a pro bono attorney, the answer is I've been paid 0 fees. But everybody in every case must file this official form known as a 2016B statement. And what it simply requires is a statement of how much you're charged, how much you've been paid, and whether there's a balance due. And you have to state who paid you. Did the debtor pay you, or did someone else pay you? And the reason is that if you're being paid by someone other than the debtor, potentially that compromises your independence because you may have loyalty to the person who paid you or who agreed to pay you instead of loyalty to the bankruptcy case, to the bankruptcy debtor, and to the creditors and to the service of the creditors as debtor's counsel. So it's important that you know exactly where you're getting paid from. And also, the 2016B statement lists all of the services that you're going to render. And if there are any exclusions from what you're agreeing to take on for your fee, then the 2016B statement is also where you list all of the exclusions from the services that you're going to render. So for example, if you agree with your client that you're going to do a bankruptcy case for them for $1,500, that does not include any litigation over discharge or dischargeability. Or maybe it does, depending on the agreement you reach with the creditor. I think it would be foolish for it to include that because that kind of litigation could be $20,000, $30,000 of legal fees easily if it's a full-blown trial. So in the 2016B statement, you would disclose the fact that your retainer excludes litigation over discharge or dischargeability. Or if your agreement is, my fee is $10,000, but it includes litigation over discharge, that's where you would disclose it as well. In every case, even if you're pro bono, you must file a 2016B statement. Like I said, it's an official form. There is very, very little to fill out. It's just boxes being ticked and blanks being filled out, with the exception of an explanation of what's included or excluded from the scope of services.
And if you don't file that initially, you get a love note from the court saying you have 10 days from this date to file this paperwork. That's one of the ones I don't wait 14 days with. I usually file immediately after I file the petition. I even file it with the petition usually. I don't put it into my 14 days with the schedule. I just file the petition, file the disclosure, file the exhibit for the credit counseling, and that's it. So make yourself aware to file that immediately.
Okay, the next thing I want you to look at are the last 2 pages in the forms section, which is called Section 341 Interrogatories. This is an example of a form that's used by one of the trustees, one of the 4 trustees here in DC. This is, I mentioned to you that some of the trustees use questionnaires that the debtor has to fill out when the debtor shows up for the 341 meeting, for the meeting of creditors in room 1207 in the U.S. Courthouse at 3rd and Constitution. And you can see it's pretty straightforward. And like we said when we were discussing what is the role of the Chapter 7 trustee, these questions are designed to find the easy money for the trustee to go and get. So besides some basic case information, they say, are you buying a motor vehicle? Do you have life insurance with cash value? We're expecting a tax refund. Does anybody owe you any money? These are easy things for the trustee to pursue to accumulate cash to pay himself his commission, to pay his lawyer's fees, and to pay the creditors in order of statutory priority. And you can see the kinds of things that the trustee also wants to know. Did you review your schedules and statement of financial affairs before you signed them? Have you listed all your assets? Have you listed all of your debts? On the second page, have you transferred anything that might be recoverable as either a preference or potentially a fraudulent conveyance? Have you sold a house? Might you inherit from somebody? Have you been involved in a car accident where you might have a claim against a third party? These are questions that are not designed to trick the debtor. They are designed to be part of the trustee's investigation into the potential assets that the trustee might be able to grab and reduce to cash. Now, each trustee's questionnaire is basically different, but they follow the same basic model and ask the same basic questions. And at the meeting of creditors, while you may fill out this questionnaire, when it comes time to have the live interaction with the trustee across the table is likely to ask most, if not all, of these exact same questions. Again, the idea being that since the trustee is a fiduciary representing the interests of the creditors, that the trustee wants to be as absolutely certain as he can be that his investigation has produced the correct result, that there are or are not assets that he can reduce to cash and pay to creditors. Now, somebody asked about an intake questionnaire, that instead of using the schedules, that is there a form that you can follow that will give you some guidance in how to get information and what information to get from your client. If you flip back several pages, after that statement of no alterations, there's a 2-page form called Initial Consultation / Intake Sheet. Why don't you talk about this? Because this is your form.
I created this form. And basically, over years, I've added and since gotten rid of things that I feel I need to ask. But basically, it's your basic information, their full name, their social security. I ask for date of birth for my own records, basically. I don't have to produce that to the court. It has nothing to do with anything with bankruptcy. It's just for me to know, basically, what their date of birth is. Address, where they live now, home, work, and cell numbers. Email addresses are key. I do all of my interaction as much as possible by email, so I don't have to be on the phone all the time. If I can shoot them an email and they shoot me back, I can get through things quicker, and I have a record of the conversations where I have. So if they come back and say, well, you never told me this, I pull up my email, forward it back, and say, yes, I did. It's the best way to make sure that you have covered yourself on things that you're asking of them and they're asking of you. Employer's name and address, what they do there, how much they make, it's very important. And when I get to a meeting with them, I want to know what's their yearly wages, so that I know in my head, I'm looking at the means test going, okay, well, it's a household of 4 in Maryland, they make $280,000, they're not going to qualify. I don't care how many times I can do deductions. I'm not going to get them down to 104 from 280 most likely. So I'm looking at the hard numbers on their salary so that I can, in my head, figure out whether we're going to do a 7, whether we're going to do a 13, or this is going to be an 11. And then I always ask if they've just started a new job where they used to work, so I can have that information. So if we have a 6-month look back, I know what their old salary was. I also get their spouse's information on the other side if they're not filing, or if they're filing jointly, I put their spouse's information here. Whether they're married, separated, divorced, widowed, and how many children they have. Maybe if they have a dependent as a sister or a mother, somebody that they take care of, that they have primary responsibility. Because the more dependents you have, the higher you can make on the means test. So I like to make sure maybe they have grandkids, maybe they have their kids and their kids. And then I get their mortgage information, I find out who's it with, what's their monthly payment, how much they owe, if there's a HELOC or a second mortgage, and then the value of the property. Normally, they come to the table, I already have done my Zillow appraisal, I already know what the value of their home is, so I already have all that so that I know whether we're dealing with an equity issue or we're upside down. Because in bankruptcy, upside down is good in the sense if you're not in DC. And if we're dealing with a Maryland or Virginia case, equity is bad, most likely because you can't protect it. And then we turn to the next page and I get their vehicle, year, make, and model, if it's got a lien or not, how many miles are on it, what kind of condition it's in, whether they have student loans, whether they have taxes. And then the whole bottom part is where I fill in all their unsecured debts, get a nice number, loans. That's where I ask them if they have life insurance, do they have a 401k, do they have any pensions, annuities, stocks, bonds, things that I know that are on Schedule B that could be potential assets. I sometimes will ask how much is in their bank account. I don't want, if somebody comes in with $20,000 in their bank account off the bat, that's gonna be a bit of a problem because I may not have $20,000 in exemptions to protect their bank account. So I need to know in order for when the schedules do come, to kind of have an idea of what we're dealing with. Because we can try to fix the problem at hand if we know what we're dealing with from the get-go. So the important thing is to get as much information about their assets and their liabilities right from the get-go where they're sitting across the table from you right then and there. Because you may not see them ever again. I usually only see them at the meeting and I usually never ever see them again, ever. So when they're there, I'm trying to get as much paperwork information as I can, because you may not hear from them again.
This is for the initial meeting, or is this the meeting with the trustee?
No, this is when you're meeting with the
Okay.
client in your office or here, or wherever you are, to introduce yourself and kind of explain the process. You try to get as much off the bat.
Okay, we've reached the part of the program where we're done. And so for the next 6 minutes, we'll open it up for any questions you may have, case-specific, law-specific, gossipy. I understand Lindsay Lohan is thinking of moving to England full-time. I heard that on the radio, so, discuss amongst yourselves. Yes?
You all were talking about yard sale value. Is there some kind of list, or we're just kind of,
Also,
Determining-
you're determining, it's your own discretion.
okay.
What you can do is, if you go to the clerk's office or get on Pacer, and you search, sort of randomly for Chapter 7 individual filings, you can take a look at the kinds of values that are put in there. And you can also look at the docket and see whether anybody objected. If somebody objects to exemptions on the basis that property is undervalued, it'll be in the docket. But you can see the kinds of values that the trustees and the creditors don't object to. And some of these things you'll laugh at. Like a refrigerator, $10. But nobody objects because nobody wants to sit around while the trustee sells a used refrigerator to see what he gets for it.
They're only gonna object to the big ticket items, things like pensions, if that maybe can't be protected, but you're trying to protect them or they don't understand them, Fabergé eggs, China, stuff like that, the big ticket items that you're undervaluing or you're not listing at all. I mean, I'm just thinking in the last 8 years, maybe one fight really over exemptions, and that was over a pension, a retirement pension. But really, they don't balk at that because they don't want to deal with it.
Yep.
I just had a question. You mentioned sort of household size dependence, like a mother or a sister. What if they live, like they're all adults and they live together? How do you do income and household size then?
When they changed the bankruptcy law in 2005 to create the means test, this was one of the hardest things, is how do you define a household? Generally speaking, a household is defined as the number of adults who actually reside principally under the same contiguous roof. Not like 3 people or 3 families live in one building made up of 3 separate apartments, but live in the same dwelling unit who contribute to or depend upon the household income generated by the others living in the same contiguous space. So if you have a working couple that have a parent and a child who are living with them, then all 4, as long as the child, well, no, it doesn't matter the age. As long as the child is residing there, that's a household of 4, even if the grandparent and the child are contributing nothing. Because they live there, they depend on the household income for their support. If they are contributing to the household income, like the grandparent receives fixed income and uses that to sort of pay their way by contributing that amount to the household, then that income has to be added into all sources of income for the means test. But you also get the extra dependent, which raises the median income considerably for that particular jurisdiction. So the definition of a household, and the size of a household, has always been something that people have struggled with. But it's sort of like, you'll know it when you see it. If there are close issues, usually the only one who fights it is the U.S. trustee, and they're not unreasonable. If you can make a good argument as to a household being, 4 roommates, if all of them contribute to or depend upon the cash flow, then that's a household of 4.
Do you
Yes.
run into a lot of people who don't remember all of their creditors?
Yes.
Like they've opened up so many credit cards. What do you do about that? Is there any
Credit
way-
report.
Just the credit report is probably the best way to
That's
do
the
it.
best way to do it. When they're forgetting something like credit cards or things which are reported through a credit reporting agency, the credit report is by far and away the best source. If somebody's forgetting a personal loan, man, there's just no way to go and, knock on their neighbors' doors or call up their relatives. I guess you could get their guest list from their bar mitzvah or something and call everybody on it and see, does so-and-so owe you any money? But that's a level of diligence that you are not required to go through.
Okay.
You have to depend on your client's ability to produce information that's uniquely within the client's ambit of knowledge. You can push them and prod them and yell at them and threaten them to try and get them to remember, but memory is an imperfect thing. And remember, if it's a case in which there are no assets and in which there is no bar date for the filing of proof of claim, they could remember it 5 years after the fact, and it's still good enough for them to be able to discharge that debt. Other questions? Yes.
Deal with the software, Easy Case or whatever it was. How do
Easy
we-
file and best case.
How do we get those licenses?
Okay, both of them are available from each of the issuers. So there's a bestcase.com and an easyfile.com. And everything is downloadable, or you can have them ship you discs.
You can do a
If
free
we-
demo to try it out, and then do that, and then get a license afterwards, but I know they have a demo.
Does the pro bono program do that?
It's here on their computers.
Yeah, they have best case on the laptop. Any other questions? Okay, listen, we are here to mentor.
Oh, this is the page 1 and 2 that
Yeah.
we were telling you that was missing for the things. We put page 1 and 2, page 1 and 2 of I and J, so if you want to grab these, you have what makes sense to it.
Okay, we are here to mentor you once you've gotten your clients through the pro bono referral process. Or if you have general bankruptcy questions down the road in the course of your practice, don't hesitate to call and brainstorm, ask questions, whatever it is that you need us to do in order to make sure that you can successfully handle whatever issues come up. In the meantime, like I said on Tuesday, please take the time to fill out today's evaluations. Let me tell you in advance, don't bother telling us how incredibly underwhelming the materials are because they're incomplete and missing things. We're sitting here sort of red-faced because of what we're finding out is missing on our own. So we already know that part. But the rest of the input, as I told you, we saw stuff from Tuesday that's already helpful. Your observations will be nothing but helpful to us, again, in determining how best to tweak and retool and tailor this program for future trainees. In the meantime, thank you very much and good luck to you.